Hello, this is Mohammed Mazul from Shubun. My student ID number is 190666914. Now I'm going to talk about a case which I have to submit by oral presentation, which I already written and submitted in my assignment portal. And in that case, I'm going to talk about Petroleumeno as I am appointed a senior legal counsel. So, on behalf of them, I would like to demonstrate this case within 15 minutes in a brief way. So, without further delaying any time, now I'm straightly going to talk about or presenting my case. Petroleumeno versus the Republic of Ecuador. The following submissions are forwarded on behalf of the claimant of for this proceeding. These submissions intended to establish whether there has been a breach of standards of a treatment as propounded in the bilateral investment treaty of 1999 between the claimant's home state, the Kingdom of the Netherlands, and the respondent. Background and relevant facts. At all material times, the claimant Petroleumeno is an oil and gas company duly incorporated and registered in the Kingdom of Netherlands, home state. At all material times, the respondent, the Republic of Ecuador, is a country in north, west, and South America, bordered by Colombia on the north, Peru on the east and south, and the Pacific Ocean on the west. At all material times, Fuel for You is an Ecuadorian petrol company owned and controlled by the respondent. On 27 June 1999, the agreement of the encouragement and reciprocal protection of investment between the Republic of Ecuador and the Kingdom of Netherlands (BIT) was signed. The BIT came into force from 1st July 2001. By the virtue of this BIT, both the contracting parties agreed inter alia to provide in its territory fair and equitable treatment of investment of investors of the other contracting party. On or about 2008, the claimant invested in three petroleum blocks inside the respondents' territory host state. Subsequently, the claimants' factories were targeted by environmental and political protesters of the host state. Several processions were held outside of the claimants' factories. The claimants' buildings were vandalized by the protesters, and access to the factories was severely restricted. Such a serious disruption in the operation of the claimant's business resulted in the production coming to a stop. The claimant vehemently submits that the respondent failed to assist the claimant adequately and or at all in these disruptive circumstances. Moreover, the respondent subsequently imposed windfall taxes of 80% on petrol exports. The sudden rise in taxes and high tariffs mean that the claimant became unable to continue with its operation. Consequently, the respondent state owned a petrol company, Fuel for You, took over the operations all of the three petroleum blocks to the claimant within 6 months. The claimant respectfully submits that the respondent has breached its obligation of providing fair and equitable treatment and non-expropriation under the VIT between the claimant's home state and the respondent, thus breaching several articles of the VIT. The merits of the claimant's claims are discussed in now. Breach 1, a failure to provide a full physical security and protection. The respondent failed to provide full protection and security to the claimant's investments contrary to Article 3, Subarticle 1 of the BIT. According to Article 3, General Treatment, Paragraph 1, each contracting party shall accord to such investments a full physical security and protection. As per Article 1, definitions, Paragraph A of the BIT, the term investment means every kind of asset, including property of movable and immovable goods. Therefore, the building and the factory premises of the claimant, along with every movable and immovable goods therein, constitutes as the investment of the claimant. A thorough reading of these clauses suggests that the respondent, being the host state, is under an obligation to take active steps to ensure protection of the claimant's investment from adverse effects. The adverse effects may stem from private parties such as demonstrators, employees, or business business partners or from actions of the host state and its organs, including its armed forces. The arbitral tribunal in Rumeli versus Kazakhstan stated that the presence of the full protection and security clause mandates the host state to ensure an adequate level of protection to foreign investment from physical damage. Moreover, the tribunal in Shaluka versus Czech Republic further clarified this provision by stating that the full protection and security standard applies when the foreign investment has been affected by civil strife and physical violence. However, as detailed above in paragraph 6 of this written submission, the respondent has failed to provide full physical security and protection to the claimant's investments. The claimant's buildings were vandalized and access to factories were restricted. However, the respondent did not do anything to prevent and or mitigate such attacks on the claimant's investment. Therefore, the imperative issue is to assess whether the inaction of the respondent amounts to a breach of the standards of treatment under the BIT or not. The tribunal in Eastern Sugar versus Czech Republic stipulated the standard of protection that needs to be provided to the investors against violence stemming from third parties. The tribunal found that where host state fails to grant full protection and security, it fails to act to prevent actions by third parties that it is required to prevent. Moreover, in Vienna Hotels versus Egypt, where the police and other state authorities of the host state took no effective steps to prevent or compensate the adverse action against the claimant's investments by a third party. The tribunal expressed that it had no doubt that the host state has violated its obligation to accord full protection and security as a part of the BIT. In the light of the above rationales, it is respectfully submitted that the respondent has failed to provide full physical security and protection, for mostly by preventing the attack from happening and subsequently failing to take any and or adequate effective action afterwards when the claimant's investments were vandalized, and thus breached the standards of treatment under Article 3, Subarticle 1 of the VIT. Breach 2, failure to ensure fair and equitable treatment FET. Article 3 General Treatment of the VIT clearly mentions that the contracting parties shall ensure fair and equitable treatment of the investments of investors of the other contracting party and shall not impair by unreasonable or discriminatory measures the operation, management, maintenance, use, enjoyment of disposal therefore by those investors. More particularly, each contracting party shall accord to such investments treatment which is in any case shall not be less favorable than that accorded either to investments of its own investors or to investments of investors of any third state, whichever is more favorable to the investor concerned. However, it is respectfully submitted that the respondent as well to accord a fair and equitable treatment to the claimant's investment. Understandably, there has been much academic and legal discussion about what is meant by fair and equitable. Frequently, it is said that their definitions are overlapping to each other. Professor Peter Machilinski stipulated that to understand the famous both the behaviors of the aggressor and the party being acted upon should be measured. He further stated that the concept of equity relates to a balancing process and weighing up of what is right in all the circumstances. On the basis of a holistic understanding of these terms, a FET clause is put in place to guarantee standard a standard of governance on the part of the host country which completes it to act in a consistent manner, free from ambiguity and in total transparency, without arbitrariness, and in accordance with the principle of good faith, ensuring that the foreign investors feel discriminated in any manner. With the above submission, it is respectfully submitted that the respondent has breached the FET clause in the VIT. The imperative issue to assess whether the actions in questions are in all circumstances fair and equitable to unfair and inequitable. Moreover, the respondent had unfairly levied a windfall tax, 80% of which has discriminately affected the petrol exports. However, as per Article 4, treatment in fiscal matters of the BIT, the respondent cannot impose taxes which results in the treatment of the investor being less favorable than that accorded to its own investors or to those of any third state who are in the same circumstance, whichever is more favorable to the investor concerned. This clause incorporates the concept of national treatment ante as a standard measure to ensure non-discrimination. These types of clauses are incorporated into the BIT to guarantee that a level playing field exists between the local investor and foreign investor. Therefore, The affected of this clause will limit the host state respondent to make any negative discrimination between its domestic or national investors and the foreign investor claimant. However, it should also be borne in mind that in the unintended circumstances where the national legislation or regulation of the host state becomes factually less favorable for the foreign investor, that the general rules for international law, a positive differentiation might be made between the foreign and national investor. In these circumstances, it might even be a duty on the host state to ensure the foreign investor receives the standard of treatment it is entitled under the customary standards of international law. It is further submitted that the claimant had a legitimate expectation that the respondent would not suddenly increase taxes in such a manner that the claimant's operation petrol exports will be intentionally targeted. In reality, the introduction of the windfall taxes has disappropriately targeted the businesses involved in petrol exports. Although the regulation does not directly discriminate between foreign and local investors, however, in reality, the business involved in petrol exports are predominantly foreign. Thus, the increased tax will affect foreign investors like the claimant more than the local investors. Therefore, it is respectfully submitted that this clearly breach of the FET clause and the standards of treatment prescribed in the BIT. Breach 3, expropriation of the claimant's investment. As briefly stated above at paragraph 6, 7, and 8 of this submission, the respondents have failed to provide physical protection and treat the claimant fairly and equitably, has resulted the claimant being unable to continue its operation in the respondent's territory. Consequently, after 6 months of hardships on the claimant's part, the respondent took over the claimant's investment via a petrol company named Fuel for You, which owned and controlled by the respondent. It is respectfully submitted that such a takeover clearly amounts to expropriation by the respondent to Article 6 expropriations and compensations of the BIT. The Article 6 clearly prohibits the respondent from taking any measures to nationalize and or expropriate or take any other measures having the same effect that deprive directly or indirectly investors of the other contracting party of their investments. However, the articles does provide three exceptional scenarios whereby such an action will be justified, which are listed in sub paragraphs A, B, and C of the article. They are if the measures are taken in public interest under due process of law, if the measures are non-discriminatory, or if the measures are taken against just compensation. The respondent may argue that such expropriation can be justified under Article 6 by stipulating that such a measure was taken in public interest to combat the rise in petrol prices and continue with the petrol extracting operations. Moreover, it is respectfully submitted that the expropriation was discriminatory and was carried out with a malified intention. It is further submitted that the respondent's unlawful expropriation has resulted in loss and or damages incurred by the claimant. However, the respondent has failed to provide the claimant with a prompt, adequate, and effective compensation equal to the fair market value of the expropriated investment in exchange of the expropriation. In conclusion, from the proceeding of paragraphs above, it is evidently clear that the respondent's actions amount to severe breaches of the standards of treatment prescribed in the Ecuador and Netherlands 1999 bilateral investment treaty. It is further submitted that the respondent has breached Articles 3, 4, and 6 of the BIT. It is respectfully submitted to the Honorable Tribunal to find the respondent in breach of the fair and equitable treatment and non-expropriation obligations, in breach of the BIT, and to issue an award stipulating the respondent to pay adequate compensation to the claimant. Respectfully submitted on behalf of the claimant. Thank you for being with me. Take care.